Thank you. Bye-bye. Now, collectively, I will approach and use two names. The one will be ladies and gentlemen, and the other will be trainee judicial officers. I know most of you are judicial officers in the Magistrates Court, but we are talking about the next level here. I did not prepare slides. We will have a discussion, and I will try to do my best to divulge some knowledge to you. Now, my main purpose here is basically to address the trainees concerning default judgments. Now, all of us know, and you will know what a default judgment is. There's one party lacking in the proceedings. Now, sitting as a judge, a general approach, when you sit in a second motion court, after you were introduced in the judiciary and you took the oath of a judge, you will always remember the following: that you took an oath and you will apply it on the procedures of default judgment. You will always remember that you took an oath that as a judge of the Republic of Namibia, you will defend and uphold the Constitution of the Republic of Namibia, and you will fearlessly administer justice to all persons without fear or favor. Now, that all persons in a default judgment context mean not only the plaintiff, that is the main party in your default judgment court and in the residual court. The other person who is not represented, the defendant, is equally entitled to your protection. And remember that always as a point of departure. The next point I want to make as an introduction is that when we talk about judicial case management, there are certain principles enunciated in Rule 1 of the Rules of Court. Now, I'm going to pick out certain of them that I always want you to apply when sitting in residual courts. And that is under Rule 1, Sub-Rule 3. Remember always that it's the duty of a judge, inter alia, to ensure that the parties are on an equal footing. Now, you will immediately ask me, but if the defendant is not there, how can you see to it that equal footing is guaranteed? You will do it because as a judge and a judicial officer, you are in the service of the community. Apart from being in the service of the office of judiciary, you are in service of the community. The day you take an oath as a judge, you are not only elevated to an esteemed cadre of members of the judiciary, you are always, from that date onwards, in service of the community. And when sitting in a default judgment court, there is nothing wrong, and I will advise you strongly to approach it, that the name on the papers in front of you, the person that's liable to become the judgment debtor, that name of that person is not only flesh and blood, it's maybe a corporation, but it is a person entitled, without fear or favoritism, to the applicant for default judgment, to the judgment creditor. That debtor, although he's not there, is entitled to your protection and your oversight. Next thing you will ask me is, but how do one do that? Many of you know the answer to that question. You do that first and foremost by looking at the substance of the case in front of you. And by looking and investigating whether the summons, and more importantly, the particulars of claim, made out a case, a triable case, worthy of judicial consideration on the papers. As in the magistrates' courts, you will also find in the High Court that sometimes certain papers serve in front of you for adjudication, which, if you have a look at the substance, although it seems substantial in the beginning, the substance becomes less and less. You must always ask yourself the question, regardless of whether the defendant is unrepresented or not, will you be able, if you find that all the procedures and forms were followed, to give a judgment? Now, we will later on go to Rule 7 of the rules and Rule 45 of the High Court rules, and we will discuss what should be contained in the particulars of claim. Still, as a general departure point, let me just intercede myself here and ask, do you understand why I say that even in a residual court, we must try and get the parties as much as possible on an equal footing? You understand that? And do you understand how you can attain that? That is, you as a judge will more actively investigate the summons and the particulars of claim. You will more actively look at whether there is triable grounds therein. I want to give you an example. In default judgment matters, more than 60% of the times, we sit with big financial institutions as the plaintiff. Either a commercial bank or insurance companies. And you will see a lot of time, if you deal with insurance claims, you will see a lot of times that there is an affidavit concerning damages, and I will invite you to look at that particular affidavit with a very critical and dissecting eye. And sir, I know you have an excuse for being late, but one of the things you must remember, in future, if you ever become a judge, you must never come late in a courtroom. Never. It is not cordial to the people inside your court. Let me take up the strands with the damages affidavit. Say, for instance, it was a car accident, and there will be a lot of defaults serving in future in front of those of you that will be appointed as judges. Then all of us know, because all of us have motor vehicle insurance, all of us know in our common day lives that almost every insurance contract have an excess term in it. So if you claim, if there's a claim for damages concerning damages to a motor vehicle, you might find the following. There's either damages in the sense of replacement parts and the value of work, or the motor vehicle is a total loss, and there's a request for judgment for the value of the motor vehicle. When you go through the damages affidavit, one of the first things you would like to see for yourself is what happened to the excess. And I can promise you, in more than 90% of the cases, you will find that the excess is not even mentioned. But with the other supporting documentation in the papers in front of you, you will be able, most of the times, to establish whether the excess is a percentage of the vehicle before it was damaged beyond economical repair, or whether it's a fixed excess. Some insurance contracts say fixed 3,000 or 5,000 or 10,000. And in the compilation of the damages, you might see the excess, but you will, more than 90% of the times, do not see that the excess is effectually and actually subtracted from the claim amount. You will find in the claim forms in front of you that the insurance company paid out the plaintiff, the insured, an amount less excess. So that 3,000 or 5,000 or 10% or 5% agreed excess go somewhere, and it usually go in the pockets of the insurance company. And in a default judgment court, there's no room for that. If there is not a particular plea inserted in the particulars of claim and quoted from the insurance contract, addressing that particular issue to your satisfaction, that excess amount, if the claim is for 100,000 and there was a 10% excess amount, when giving, if you are going to give the judgment, when giving the judgment, you will subtract the 10,000 or the 3,000 or the 10%. Why do I say so? Because the defendant, the unrepresented defendant, was not a party to that insurance contract. Ensure that the unrepresented defendant pay only actual damages if you are satisfied with all the other proof that they attach. While I'm on the topic, ensure that when part of the damages affidavit or damages claim is the rental of a substitute vehicle, be sure that somewhere in the particulars of claim or in the damages affidavit appears the following: that the assessor has found that it is reasonable and necessary expenses. A lot of times you get this just added on as an item, but there's nowhere any mentioning in the particulars of claim concerning that. And then to make it worse, there's nowhere any credible allegation concerning those damages in the damages affidavit. While we are on this topic, and still with motor vehicle accidents, remember that even if you don't see the name of an insurance company there, usually an insurance company, in terms of the insurance contract with the plaintiff, after they paid out the plaintiff, is instead of the person with whom the contract was concluded and under that person's name. Further, remember that nowadays, and that is a trend that I could see for more than the past decade already, even when I was in practice. Nowadays, we don't have these kind of experts and experts' affidavits anymore that say, I am an expert valuator, an expert on the damages sustained on a vehicle after an accident because of the fact that I was a mechanic for so long, I was a manager for so long, I was in the accounts department for so long, therefore I knew the prices of replacement parts, I knew the prices of work reasonably expended on the matter. You don't find that anymore. Most of the assessors we have nowadays were trained by the insurance companies. And they effectively rely on their training by the insurance company or insurance company to say that they are an expert. And because the matters are undefended, their expertise are never tested in court. And then you get the following, and that is why I was mentioning that. Then you get the following statement, that the value of the wreckage, you get it in that damages affidavit compilation. You will get that the value of the wreckage was 10,000 or 11,000. You will never get something 11,533. In any event, you will never get cents. Why? Why? Because no expert ever went to the damaged vehicle and expertly assessed the damaged vehicle The right fender should be replaced, yes. Value thereof, which they must check afterwards. Because it's a wreck. They don't do that. But now they also don't give you any valuation of the second-hand parts that might be get from that vehicle. Maybe the engine is not damaged at all. Maybe the engine is not damaged at all. And then when you investigate the papers and search the papers, you will see that the amount, the salvage amount, come down to the following. It is an agreement between the insurer, of which the defendant was no party, and a tow-in company, that after the towing of a vehicle, that preferred company, there's usually an underlying contract with certain tow-in companies and salvage companies, that if it's a write-off, you buy the wreckage from us against 3% of, or 5% or 10% of the value of the vehicle before it was in the accident. A fixed amount again. An agreement again that was not entered into with the defendant. The one whose rights you should also protect. Now, Ms. Mokomela did a lot of advices to judges over the past 18 months and bench memos concerning default judgment that will serve in front of them. And she will be able to confirm that it's very seldom that judges go so far to look thereat. But what I want to tell you is that it is your duty as a judge to make sure when you accord damages against a person who has either elected not to defend the matter, most of the time did not elect that because he knows that he caused the accident, and from there onwards they accept whatever damages come their part, whether they can pay it or not. But I repeat again, it is the duty of a judge not only to give heed to advices or bench memos uploaded on the e-justice system or filed on paper files. It is of great help that we have research assistants. But the moment we as judges start to be a rubber stamp on the work of, most of the time, a big commercial firm, and our research assistants, we are in dereliction of our duties. You must have an investigative mind when you look at damages. And you will see, ladies and gentlemen, that I'm not even at procedures at the moment. It go about a value of a claim. Now we can quickly refer to Rule 15(3) of the High Court rules. And that gives you the alternative, what you should do. If you have doubts about the damages in front of you, don't dismiss or just remove or just strike the matter in front of you. Then it's your duty to give directions. And you are entitled to give directions. Postpone a matter to a next residual court hearing, or remove it, and then instruct that you want to receive either oral evidence on the issues that are of concern, or that you want a proper affidavit concerning those issues. I did it a few times in the last 18 months to remove or postpone matters with instructions that I want an affidavit on these points, or I want oral evidence at a future date on these points. You will find that litigants then try to patch up by filing affidavits, which you can accept or not accept. It's in your discretion. Even if you have ordered them to lead oral evidence, they prefer to file affidavits because an affidavit cannot bite them, or so they think. And an affidavit cannot be examined orally by the judicial officer. But it's your prerogative. If you have doubt about the damages, ask and direct specific issues to be conducted in front of you by way of oral evidence or by way of affidavits. Then you have done your duty, but you have done something else too. You have enlarged your workload a lot. If you are meticulous with that, you enlarged your workload. Let's go back to the beginning. You are in service of the community as a judge. And if you have red eyes day after day, like mine, there can be different reasons for that. But you are not in a glamour post. You are not in a glamour post. And that is something that I want, and you will be addressed concerning ethics by Judge Masuku. But one of the core principles I want us to understand from the beginning is, when you sit in a residual court, don't regard, as I have seen and heard from certain role players. There's no one in front of me, it's only the plaintiff in front of me. I will give the judgment as asked. Or why can we not give the judgment as asked? If they wanted to defend the matter, they should have entered appearance to defend. We come back to an equal footing, ladies and gentlemen. There is people in this country, the majority of people in this country cannot afford legal services. Cannot. We should not be feelingless for those people. We are also in their service. Now, I know when I start to talk, I sometimes veer from a topic, but I think until now I want any judicial officer to approach a default procedure in front of him. Never if there will be no recourse. That's a dereliction of duties. you step in. What I do not say is that it must be difficult to get a default judgment in front of you. No, that's not what I'm saying. But if you give a default judgment and can attain that in 70 or 80% of the cases, you have done justice, then it's good. There's always factors we will not know about because there is no defense in front of us. And because there is not an inquisitive eye of a legal practitioner on the defense side. And plaintiffs are entitled to judgment by default if an appearance to defend was not entered timeously, or if a pleading, and remember that, if you look at Rule 15.2, if a plea was not filed timeously. I don't know whether there's a comparable provision in the Magistrates Court rules, but we look at Rule 15.2 and see that if a defendant fails to deliver a notice of intention to defend or a plea, there might be a notice of intention to defend, but no plea was delivered, they are also entitled to default judgment. What I'm saying, and I will repeat it, I don't want to take away the entitlement of a plaintiff to get default judgment, but that plaintiff should scrupulously follow the procedures. We are very strict on that. What I ask of you is that look at the material terms of the matter. And when you look at the matter before you grant default judgment, it is not on anymore in a court of law, especially, I cannot talk about the Magistrates Court, especially in a high court. It's not on anymore to say the bare minimum in your particulars of claim and attach a lot of papers and say the papers attached are made a part of my pleadings without quoting what you want to bring to the fore. It's the duty of a plaintiff or a litigant. It's the duty of the legal practitioner, if the party is represented, to plead the particulars in the particulars of claim. If they want to attach documents in the particulars of claim, they must refer to clause so-and-so of Annexure A. If they do not quote it, it must be incorporated in the main body of the particulars of claim, what they want. One get a lot of times that you get a wishy-washy type of particulars of claim. Legal practitioners do not give a lot of attention to what really is standing in the contract that they attach concerning cost, for instance. It has become a custom to ask for cost in matters like we are discussing now, a custom to ask for cost on a scale of attorney and own client. And a lot of times, if you are going and researching the document, you might see costs on an attorney and client scale. Number of times you will not even get a reference to attorney and own clause, attorney and client scale, except when it's a bank and it's concerning a bond and a home loan or a loan to buy a car. You will get that. the banks have their own legal personnel in their service. If, and with general reference, again now also to Rule 45, and all of you have the rules of court in front of you. If someone rely on a contract and attach a written contract, if you have a look at Rule 45 sub 7, you will see that it talks about a true copy. A lot of times you will not even find a reference in the particulars of claim to a true copy, and then on top of that you will not see on the annexure attached to the particulars that it's certified as a true copy. Now, there's still a type of debate going on whether it's necessary to certify each and every agreement that you attach, officially certify it as a true copy. I'm not going to enter into that debate. If you follow the rule and the rules say a true copy must be attached, then the allegation in the particulars of claim must be a true copy of our agreement is attached here to marked A. In general, most of the contracts that you will find attached to particulars of claim in a default setting, as in other litigious settings, if it's concerning money, with a few exceptions, always remember to look for either a stamp, an ink stamp, or a real revenue stamp that the revenue duties were paid. That is your duty as a judge. And that is in terms of Section 12 of the Stamp Duties Act. Now, I want us to pause at this juncture and give you an opportunity. We talk about a default setting now concerning insurance contracts, motor vehicles, etc., where big commercial companies act as a plaintiff in the matter. Any observations, any questions from any of you before I move to commercial banks? Sir? Just that, while we start, if you ask me a question, just tell me your name also. I will start to remember it by tomorrow. Then, number one, that party, I had a case like that a few weeks ago. Then the party, the plaintiff, did not comply with my court order. I called for oral evidence. The second sub-part of your questions might relate to the following. When would I, for instance, call for oral evidence instead of an affidavit? Well, I will do it if I have doubts about the expertise of the person making the initial damages affidavit, after reading through it. And after taking heed of what is the requirements of an expert, which is very neglected in the everyday procedure of the Magistrates Court, sometimes in the High Court. When a person comes and say, I'm an expert, it's not your duty to believe that person. Look with criticism why that person say in his affidavit that he's an expert, or she. I think about a specific person, Mr. Mulima, which for a few times now already, and I will not say what sex is the person, but for a few times now already, the person stated the expertise, the grounds for that, and if you just on the affidavit applying the principles of what the expert should be, then you have a lot of doubt. This specific person is one of the people that we find in a lot of the motor vehicle accident cases who say that they become an expert because of the allegation or fact, they say it's a fact, that he or she is in service as an assessor of a specific insurance company for the last 6 years or 7 or 8 years and have received training and has testified, and that testified immediately put it in a quotation, has testified in court for so and so many times. Usually it was affidavits. Usually no one have doubted their expertise. And then when you look through the affidavit and the material of the affidavit, you quickly pick up the question of the excess, the question of reasonable cost for hiring another vehicle, the question concerning salvage value. And they just, like, I don't know the English term therefore, but they are just repetitive of what is expected of them. And then putting all the matters down and then want to veil it in a general cloak of expertise. And they cannot be an expert on all the matters. Usually an assessor cannot be, a normal assessor cannot be an expert on salvage value. And when you ask them to come and present oral evidence, you see that. They have no basis to say that they are an expert. But they say they are experts because of the fact that they repeat certain procedures for many years. Now, ladies and gentlemen, repetition has never made anyone an expert in anything. Anything else? So in short, to answer your question, your feeling will tell you that. When you investigate the affidavit, your feeling will tell you. Oral evidence, affidavit. You start to know, because of the number of cases you see, which so-called expert you can just rely on. But query in your mind when you read through the matter, query it constantly. But then you will see certain people come on time and time again, and it's flawless. And the one time that you ordered oral evidence, they were bona fide. So you get the feeling. You also get the feeling for the imposters. I want to call it imposters. You get that feeling quickly. For an imposter, you don't ask an affidavit. It's easy. Most of the time, they do not even draft the affidavit. As in a lot of legal matters in front of us, now I'm not only talking about default matters or residual court matters, a lot of affidavits that we as judicial officers see, either in applications or in the default setting, whatever. It's the phraseology of the legal practitioner. And some legal practitioners can never or never lost the attraction of basically panel beating the case on behalf of their client, because they believe that that is what they should do, which is very wrong. We also see that in witness statements. It is not, and then someone come in front of you in a normal case in the court under our new rules, and they are placed under oath. And they start to give evidence, read the statement afterwards, this cross-examination, and then quickly. But I did not mean that. I did not say that word must be in. What I said is this. Can I change it? Legal practitioners sometimes do their clients a disservice of framing matters in legalese. If there's no further question or discussion at the moment concerning the damages issue, I cursory want to discuss with you in default settings the role of big commercial enterprises like banks. And most of the cases you will ever find on your default role will be commercial banking institutions. Again, your point of departure, apart from the procedure, apart from the practice directives, your point of procedure in those matters, although it takes time, is not only to rely on advices. You are the judge. You have sworn the oath. You are in service of the community. All bond agreements do not look the same. Most of them do, but not all. If you find in the particulars of claim the very common, and mostly in this commercial type of contracts, bond contracts, until today you find it. You will find it in other default matters in front of you too. But it has become a liability. And a punitive liability in the eyes of some of the commercial institutions if I am married in community of property. You get a claim saying that on a certain date, a certain official of the plaintiff, representing the plaintiff, has entered into agreement that was put in writing afterwards with the first defendant, and the first defendant has signed Annexure A or B or whatever, and then you find a second defendant. The liable spouse, and you will get the next allegation without substantiation. the second defendant, XYZ, is married to the first defendant in community of property, residing at so-and-so address. Then you search the rest of the particulars of claim to find an additional allegation. Why, if the plaintiff entered into a contract with the first defendant, do they ask for the court to give judgment jointly and severally against the second defendant? And if you ask that question in court, the legal practitioner 70% of the times raise and say, but they are married in community of property. So what? So what? You ask them the question, yeah, and? No, but it's a common estate. Yeah, and? No, but my lord or judge, that is our law. You see, what is the law? No, that the wife, the unsuspecting wife or the unsuspecting husband, sometimes it's the girls that enter into the contract. Because they are married in community of property, the plaintiff asks for judgment against the second defendant, and a lot of times get that without the necessary allegations. It is not enough to say that there's a marriage in community of property. In most of the larger commercial transactions. And ladies and gentlemen, that you will find in section 7, also 8, 9 and 10 of the Marriages Equality Act. But in the mind of a lot of legal persons, students, practitioners, judicial officers, we were made to believe in the past that it is enough to allege a marriage in community of property. But if it's a credit agreement for a car, for a house, most of the larger credit applications, you need the written consent of the spouse. They must allege it in the particulars of claim. If the written consent was given, they must attach proof of that written consent. Unless in bond transactions, you will get that although the agreement, the initial home loan agreement was entered only with the husband, the power of attorney and the bond registration, those documents attached, you will get the two people. Married in community of property, you will get the signature on those documents of the husband and the wife. Then it's fine, then you can give it a judgment, jointly and severally. But if you start to investigate the basis upon which a spouse is brought into the equation, it became unjust. Because the next question that legal practitioners ask me sometimes in chambers or in court is that, but it is a joint estate, not so? Yes. And? Why should I give a judgment sounding in money for a debt against a non-consenting spouse? That particular judgment will have the effect that that spouse become uncredit worthy for the next 30 years. I come back to my introduction. When you took the oath, you became a judge of the people. You became a judge of your community. And you are also in their service. You must be inquisitive all the time. Let me stop there. Do you want to ask me questions concerning this second defendant issue and joint and several judgments? If you want, you can do, but I also want to extend an invitation to you. Please look at those sections, especially section 7 of the Marriage Equality Act. And then you can also look at the exceptions in section 8 of the Marriages Equality Act. And most of the time, you will find that if the drawer of the particulars of claim made the correct allegations in terms of the law, you could have granted judgment jointly and severally. What do I do in matters like that, if it comes before me? To the irk of a lot of legal practitioners, I do one of two things without hearing them even. If they didn't make out a case against the second defendant, that is what I say, the spouse, the liable spouse, who was not a party to the contract. I either remove the whole matter from the roll, give them a reason, or, and what irk a lot of the legal practitioners, I only give judgment against the spouse that entered into the contract. And I make my judgment final. And then you will find the following, and we also find it in the High Court, that the practitioner stand up and say, but my lord, on my brief, I do have the written consent of the spouse. It's not in your papers. Sorry lady, sorry sir, it's not in your papers. You have opted to go with that papers to court. You are raising in court and you say, my lord, the papers are in order. I ask for judgment in the following terms. You will also find, presiding in matters, that due to a workload, an excessive workload, practitioners do not, I think they have a choice how much work they take on. They think not, because there's commercial contingencies. There is a target to make at the end of the month. There's a target to make at the end of the year. There's an overseas trip to pay. There's a very expensive car. They budget it into their fees. They take all into the work. We should not be sorry for them about that. If you take on the work, you must give attention to your work. You are sitting as a judge. You are sitting as a presiding officer. If an officer of the court rise in front of you and tell you, my lord, my honor, the papers are in order, you are entitled to assume and to accept that a legal mind, a legal investigative mind, went through the papers, procedures, and the pleadings in front of you before making that submission. But nowadays, the whole thing became watered down. We will find that a clerk of a legal firm or a secretary of a legal firm will go and do the checking on the default files and file what we know in the High Court as the Annexure 9s. They check and they say who will appear. Now that particular attorney who will come and appear is mostly a junior, overworked employee of that particular legal firm, which must run from my court to the next court and to the next court in Katatura. They got the files, they don't check the files as is their duty. They raise and say the papers are in order. And then when you start to query them and they start to investigate, even in court, they will tell you, but here I have the written consent. Worthless. Worthless. I can assure you, Judge, that the bank would not have done it this and this and this way if worthless. Put it in the particulars of claim. Make the allegations in the particulars of claim. Since I started in the beginning, if I had a default role in front of me, I sat in court for many hours, because sometimes we have 1:30, 1:34, before the judges start to share the work like in the last number of months. In default matters, there's a dividing list. Although I'm the default judge, say on Friday, and you will experience that, we will come to that. Some of the other judges have taken away of the matters granted in chambers. Since I started to be a judge, and since especially this innocent spouse thing we are talking about, I got legal practitioners asking for matters to stand down, get a senior practitioner, come to court. No, they want to file now heads of argument. They want to address, and I say, no. You have submitted that the papers are in order, address me now. They cannot, because if they go and look, they cannot pass muster because the necessary allegations they did not make in the particulars of claim, although they could have made it if they have given attention to the drafting of the particulars of claim. If you look at this legislation, you will find that there's provision made therefore. It's basically the duty of the credit lender, the credit grantor, to go through certain procedures. The people married now in community of property, the commercial entity must know that they cannot execute or cannot get judgment against the innocent spouse if there's no written consent. The example maybe you are after is the following. When the contract was entered into and all the papers were done, there were no innocent spouse. Yes. But then, the innocent spouse should not be second defendant at all, in any event. It might well be the communal property, which became the communal property afterwards, that is the subject in future of maybe execution. But again, I say that a judgment against and please, I use the term innocent spouse in a very defined manner. The judgment should not be given against the innocent spouse, because if there's no consent from her or his part, you make that spouse without the necessary allegations, liable to be a judgment debtor for the next how many years, and the credit worthiness of that particular person is affected for many years in future. And that is not fair. That is basically what I'm saying. Yes. Look, the moment the plaintiff could not or did not do its work properly when seeing to the drawing of the particulars of claim, the plaintiff and or his legal practitioners, they practically, yes, I concede, they created problems because you have now a judge that look at the matter, or a judicial officer, and say, no, but I'm only granting judgment against the first defendant because it's the first defendant that's liable. Practically, we all know that the so-called innocent party, the second defendant, is living with the first defendant. It might be, and we will come to that tomorrow afternoon, it might be the primary home, if a home is the subject. What happened? Well, in practice, I think it became only more difficult for the judgment creditor to obtain execution. If there is a party that there's no judgment against, that's living in the same place as his or her primary home, then obviously the court will look at many other ways. But that might be, I don't know, that might be a factor at the end of the day, at the second hearing for declaring a house executable. It might be the escape route of that couple, that execution will not be levied against their primary home, if it's a primary home. Look, they will, the plaintiff will argue that the whole property become executable, and most probably they might get an order of execution at a later stage under Rule 108, because the parties are married in community of property. I'm just looking a bit at the other side and say it might make it easier for the respondents, the judgment debtors in a 108 scenario, to evade the execution. It might. In practice, depending on what is put in front of the court in the affidavit tendered by the judgment debtors, that will depend case to case. But obviously, it is easier for a judgment creditor to get execution at the end of the day, after a lot of procedures, if the papers initially, upon which default judgment was granted, was drawn properly, and they obtained a proper judgment. Interesting sake, and I would not be able that we discuss all the questions, but I just want to give you a lead. Interesting sake, you will see under Section 8 of the Marriages Equality Act, and look, I don't have the act in front of me now. It might be anywhere sub 3, 4, thereabout. You will find that judgment debtors or judgment creditors may execute judgments certain commercial transactions, despite the fact that there was no written consent, if the judgment creditor did not know about the real facts, they cannot be penalized. Judge or execution will be levied, but there is then the rights of the second defendant, the innocent spouse, the non-consenting party, concerning a claim against the spouse, when at the end of the day, for instance, the marriage is dissolved. Then again you can look at the particulars and the provisions contained in the Marriage Equality Act. There then lay a valid claim for the second defendant at some stage, usually when the marriage is dissolved. Should this be an opportune time that we just go and walk a bit around outside? You can cut it. Do you still first want to ask a question? Yes. No, then we do it afterwards. Okay.